The last section that we have in this deck deals with teachers and staff implementing the IEP. And a lot of what we're going to talk about for the next 20 minutes or so is compliance, like the ways you can get into trouble for not implementing the IEP. And 1000%, I think every one of you that supervises staff, whether you're a superintendent, a principal, a special ed director, you should be telling your staff, look, this is a job expectation and you will do it. And if you don't do it, there will be negative consequences. That's what bosses do. I also think, and that sometimes as attorneys, we don't spend enough time on it. There are, in addition to the negative consequences, there are aspirational and positive ways to motivate staff members to implement IEPs. When I get a chance to have time with the staff about implementation issues, I try to do both. I have some videos I show about how awesome some special ed kids have been after they graduate and are successful. I have sort of some like thought projects we try to do, and I'm not saying I'm a psychologist or an education leader or anything like that, but I just want you to see we need, I don't want to say carrot and stick because that's not exactly right, but we need to have the positive and the negative in terms of implementation. And the meanest teacher in America did not go into education because he hates kids, right? And so we should be able to take that innate desire in most staff members to serve special ed kids or to serve all kids, and then feed that innate desire with some kind of positive reinforcement for serving special ed kids. And I think sometimes as attorneys, we get too bogged down on the negative and forget to talk about the positive and aspirational, and that, you know, you get that shot of dopamine in your brain if you're a teacher, if somebody says how awesome you are for serving all students. So I'll just, you know, I'll leave that out there to you as education leaders to think about doing the positive and the negative. Now, going on the compliance side, so sort of the negative side, sort of these are the rules and you will follow them. The law is super clear that every child must, or every teacher that has this child must be able to access the student's IEP. And SRS is awesome because everybody can get on SRS and see it. That means case managers who are listening to this, you should give access on the IEP to every single kid that sees this kid during the week in an 8th grade, you know, setup or a high school setup. What did I say?
You said every kid.
Sorry. Sorry. Eventually we were going to have a sleep deprivation moment. Every teacher who sees this kid should be on SRS to have access, right? Even subs should be able to at least know what this child's needs are. Now, substitute teachers maybe don't have to be able to see the entire IEP. Maybe they just need that services page. But everybody that sees the kid on the regular, the art teacher, the music teacher, the classroom teacher, they should be able to access that IEP. The reason for this, the reason I'm emphasizing this so much is this is one of the things that OCR has figured out is easy to check in Nebraska, right? They ask for the SRS permissions sheet, and I've even had them ask for the SRS access records. Yes, Mr. Williams?
What about bus drivers?
Bus drivers are going to be able to know what a student's needs are on in a transportation context, even if that's confidential special ed information, right? So Joe the driver needs to know that Bobby can't get touched because if he gets touched, he gets escalated, so that Joe the bus driver doesn't pat Bobby on the shoulder as he walks down the aisle after checking that everybody's sitting down. And Steve's right. Sometimes, I assume what you're saying is sometimes we have schools go, well, the teachers need to know, but the lunch lady doesn't need to know. The bus driver doesn't need to know. They might need to know, depending on the kid's needs. So every teacher, related service provider, or any other service provider responsible for implementation has to be able to access that IEP. And again, not just the services page or not just that like IEP at a glance, the entire document. They don't have to have read it, but we have to have made it accessible. And then this is just a Montana case that proves our point, where the State Department of Education said that a school was out of compliance because they couldn't show that teachers had been able to access the IEP that they were responsible for. So on SRS, make sure that you have given everybody access that needs it. Now, again, I have teachers who, how do I say this nicely? I have teachers who are not always 1000% certain that every single accommodation in an IEP is necessary, right? And I talk about the fact that if you're sitting in an IEP meeting, and you've all been there, where mom is saying, you know, Cody just can't do math. It's too hard for Cody to do math. He needs a calculator. And you can see that 6th grade math teacher start, even if she doesn't roll her eyes in front of everybody, you can see her inside herself rolling her eyes. She leans back in her chair, she rolls, she folds her hands, she goes like this, and you start to see, okay, teacher's not digging what mom is saying. Now, at that point in time, it is very appropriate for the 6th grade teacher to say, you know what, mom, I just disagree. I've seen Cody in the classroom, and he actually has pretty good math attack skills, and sometimes he gets hung up because he doesn't know his basic facts, but he does know good things about orders of operation. There's nothing wrong with the teacher pushing back. But what we see over and over again is the teacher kind of leans back and crosses her arms, and then the IEP team writes something in the IEP like, Cody can access the calculator as needed. Now, if you've seen that 6th grade teacher non-verbally, internally roll her eyes, even if she's been professional, if you know the 6th grade teacher is not down with that, and you write calculator as needed, what are the chances that that 6th grade teacher is going to say Cody needs the calculator, right? And you put it into the IEP to satisfy mom and to placate mom, but now what you've really done is you've left yourself wide open to an implementation argument from mom that 6th grade teacher didn't implement the IEP. So I think you should gently encourage your staff that when they think an academic accommodation isn't appropriate, the time to speak your piece is in the meeting. And then if you discuss it with the team, and the team says, nope, Cody needs a calculator, then you need to follow up with that teacher one-on-one if you're her supervisor and say, look, understand, Mrs. 6th grade teacher, the team decided Cody needs a calculator. That means you have to give him that access, right? If the teacher does not follow, doesn't give Cody that access to the calculator, the school district is going to have legal problems. And there's really 3 different areas where we could have compliance issues. One is a Rule 55 due process complaint. That's actually my favorite. I actually like trying special ed due process cases. I don't think we get enough of them taken to hearing. If I could advocate for more of them, I would. But it's my job to do what's best for you guys, right? And I think the education community in Nebraska has done a really good job of minimizing the Rule 51 complaint, or the Rule 55 complaints, the due process complaint. The second way the school can be liable is an OCR complaint. And as we've seen due process complaints go down, we've seen OCR complaints go up. Parents have figured out that it's free to file an OCR complaint, that they can kind of get an authority figure to come in and boss the school around. And the problem with OCR is they want paper, right? So if the teacher in 6th grade says, oh yeah, I gave Cody the calculator, in a due process hearing, we can put that teacher in front of the hearing officer and have her testify. In an OCR complaint, before the OCR ever sets foot on your campus, they're going to say, we want all the documentation proving that the teacher gave Cody the calculator. And the teacher's going to say, well, I did it. I didn't write down every single time. So I want you to start thinking about if you have accommodations in the IEP that are hard to document, how are we going to prove that, right? Because that's what OCR is going to want. They look at the paper first, and they pretty much made up their mind on the paper before they ever interviewed a teacher. So paper really, really matters for OCR. And then the third way that a district can be liable for a failure to follow the IEP is a Rule 51 complaint. Rule 55 is due process, where you have a hearing. Rule 51 is an investigator from the Nebraska Department of Education comes out and looks at whether or not you've complied. Again, when I say comes out, I don't know if I've ever had an investigator from the department for a Rule 51 complaint come to the school. They do it all on the paper. I think the people that do these investigations at the department are really fair. I think we've had some, I haven't won every Rule 51 complaint, so obviously they get it wrong sometimes. But
she said modestly.
Yeah, no, I do think the Rule 51 process is, I'm not complaining that they're unfair, but they don't come and interview people. So again, you need paper to establish with the Rule 51 complaint that you have actually implemented the IEP. So you notice that 2 of your 3 options to prove compliance has to be on paper, and the third one is not the one that you want to go through because it's the most expensive and most fun for the lawyers. So you need to paper the file. That's my point. The third bullet point on this slide talks about the implications for the individual teacher if they don't implement the IEP. Doe versus Withers is a case from 1993 that we talk about all the time because it's the most egregious, kind of outstanding example of a teacher being held to be liable for failing to implement the IEP. Old Mr. Withers refused to give John Doe the accommodations in his, I believe it was a social studies class that the kid was entitled to. Kid sued in state court in West Virginia and won money damages, won $10,000 for Mr. Withers refusal to implement the IEP. Those cases are out there. You can find a scattering of personal liability cases, and we can come and scare your staff in an in-service with those examples. But what they really should be worried about is not the money damages claim, it's the PPC complaint. Probably Steve and I have been doing this for the same amount of time. We probably had, I don't know that I had a PPC complaint for failure to implement in the first decade we were doing this. And then now all of a sudden, parents, just like they found the OCR, they found the PPC process. And so a parent files a PPC complaint against an individual teacher or an individual administrator saying, Jordan Johnson, the classroom teacher, did not implement my kid's IEP. That's a violation of Rule 27. Just like we've had turnover at the department in special ed, we've had turnover at the department for PPC investigations. They have a new investigator and a new attorney, both of whom are excellent, but they're also, I would say, more aggressive. We've had more trouble defending these kind of claims than we used to. And again, they want a lot of paper proving that you have done the thing or that you haven't done the things that the parents allege. And so talking to a teacher about, look, if you don't implement this IEP, they're going to come and investigate and take action against your certificate. That's, as someone that used to hold one of those certificates, that's highly motivating to the teacher. And I think we should be explaining more and more often. It's not just that you throw up your hands and say, this school sucks, I'm out. Your individual certificate, this obligation to follow the IEP follows you as a certificated professional.
And it helps you when the parent is crazy and making it all up.
Yeah, that's right. It absolutely helps.
Smattering of those.
That's exactly, well, I would say as many PPC complaints, I wouldn't say they're all crazy parents, but a lot of them are. But having that documentation is your only defense against a crazy parent. Couple of examples of how teachers really have no choice but to follow the IEP. This is so old, but I love it. This is from a OSEP letter from 1978. This is when the IDEA, actually was the Education of All Handicapped Children Act at that time, had just gone into effect. And the NEA, the National Education Association, the union for teachers, was kind of pissed that this had gone into effect. And so they approached the Department of Labor and said, hey, this new federal law has passed, and schools are telling teachers that they have to implement these IEPs. And we all know that that's bogus. So tell us, Department of Labor, what procedure should a teacher follow when he or she disagrees with the contents of the IEP, or when the teacher says, I don't want this kid to be placed in the place that the IEP team has said he has to go. Now, it's 1978, Jimmy Carter is president, very union friendly. This is when public unions, I don't want to say at the height, but at a very politically powerful point in time. And so the NEA made a political judgment that the Department of Labor was going to support the union, and I would not say that that was a bad guess at that point in time. So NEA says, what does a teacher do when they don't want to do this IEP? Second question that NEA said is, if the teacher disagrees with the IEP, do they have a right to call for an IEP meeting to get this changed around so they don't have to deal with this child? And then third, can a teacher refuse the placement of a handicapped child? And you can tell the age of this letter since we're using this terminology. Refuse the placement of a handicapped child into his or her classroom. This is the teacher that says, I ain't gonna do it. That kid is violent. I'm not gonna have him in my classroom. So the NEA goes to the Department of Labor and says, okay, just tell us how we handle all this from a union side. And the Department of Labor basically told the union to pound sand. Teacher has no right to refuse to implement the IEP. No right under federal law, no right under labor law, no right under state law. Number two, teacher has no right to refuse placement of a kid in his or her classroom. If the team has decided that the classroom is the appropriate place for this disabled child, even if the teacher thinks the kid could be violent, the teacher has to figure out how he or she is going to manage that in the classroom. And then look at the third bullet point, because that's super relevant for you guys as administrators. The Department of Labor said, hey, and by the way, we've reached out to the Department of Education, and jointly, DOL and DOE, we expect schools to discipline teachers who don't comply with the law. So you can't just with a wink and a nod say, it's okay, teacher, we know that you don't want this kid in your classroom, we'll work with you on that. You have to implement the IEP, and if the teacher won't, we're expected to discipline them. It's not very often that the Department of Labor tells the union to pound sand, so it just entertains me a lot that this letter, and it's super clear, laid out well. Yes, Stephen?
Going back to the previous issue, would an IEP at a glance suffice for informing support staff, basically a summary?
So the problem is, let's go back to it, and if you're following along on paper, run back to this slide that the heading is Informing Teachers of IEP. Here is exactly what it says. The CFR says the IEP, not the IEP at a glance, the IEP must be accessible to each teacher, that's easy, related service provider, that's your school site, your speech path, that's easy, or any other service provider responsible for the implementation. The question is, if the bus driver is providing the service of transportation, does the bus driver have to be able to access the IEP? And I think if the bus driver is asking to see the IEP, we have to show it to him or her. Now, I think IEP at a glance, and maybe with a sticky note to the bus driver saying, if you need more information, let me know. I think you could prove that the IEP is accessible. Or if you train all your classified staff, like an in-service at the beginning of the year, hey, paras, cooks, and bus drivers, just so you know, you might have access to an IEP at a glance, but if you need more information, let me know. I think you could prove access that way. So I don't think you have to have an SRS login for every one of your bus drivers, but you have to prove that in some way you've made a path available to that bus driver for the IEP to be accessible. Anybody want to chime in? Bobby, I see
I
you
was just
rocking
gonna
and nodding.
Jordan and I did an
You gotta
in-service
stand up because
earlier.
they can't see you.
Jordan and I did an in-service together earlier this year. And the question was, so we have to give SRS access to every staff member? And I think the answer to that is no.
No.
But if you're just giving the IEP at a glance, how are you going to prove that the full IEP was accessible? That's the question,
Yeah.
right? Do we have to print a paper copy and give everybody the stack? No, I think the answer is pretty clear. Do we have to make sure that anybody who could implement that IEP and is a service provider has access to it? Yes. How do we prove that? Up to you. A million ways to do it, right? Giving them login access to SRS is not one of those you have to do. It could be as simple as a checkbox.
You could do the IEP at a glance, and the cover email could be, any of you that want to see this kid's IEP, just let me know. If you're old like me, remember the old days when we had all of the special ed files in a paper cabinet and like a key, and you had I remember I had a login sheet that you had to sign on the front of the folder saying that you looked at it. You could go old school and say, everybody has to sign this, showing that they had the ability to access it.
That was the second question. If we have to give them access, we have to make sure they read it.
No.
And strange as this sounds, right? The reg says access.
Yeah.
How many bus drivers are going to want to come in and sit down and read every IEP? Probably a goose egg, right? But understand the difference between what the legal standard is and what you could do and how you could document it.
SRS has made life easier, but don't forget that SRS is not the only way. And if you're in Millard and Lincoln, I think, are the two schools that aren't using SRS right now. If you're using some other format, an online system, a cloud-based system, is not the only way to prove access, but it's one way.
I will print you a copy, can be sufficient.
Yeah, absolutely. Say that makes it accessible. Okay, clicking along. Anything else? Any follow-up on that? Let me know. 7 minutes. Okay, I'm good. So letter to anonymous. This is just, it's negotiation season. If you are not a superintendent or a board member, you may be blessedly unaware of that. If teachers want to collectively bargain to set maximum caseloads, that is not a mandatory subject of bargaining in Nebraska, and I would absolutely, positively never, ever get into that, put that into a collective bargaining agreement. But in this case, and I think this was a California school, the collective bargaining agreement had set the maximum caseloads for speech pathologists. So as they're doing services in the IEP meetings, they didn't keep a list of every path's caseload. So it ended up that they had more kids needing speech services than they had speech pathologists. The collective bargaining agreement also gave teachers the right to refuse to serve kids that they deemed unsafe. Again, obviously, you should never, ever write that into a collective bargaining agreement, but this school foolishly had. So a complaint is filed or a letter sent to OSER saying, hey, our collective bargaining agreement gives us the chance to control our caseloads and refuse to serve. So just confirm that we can say no thank you to this kid. And the school said, confirm that if our collective bargaining agreement makes it impossible for us to implement the IEP, that we don't have to. And OSER said, neither the teacher nor the school district can use the collective bargaining agreement as an excuse not to implement the IEP. And we have a quote here: the IEP team determines that a particular child with a disability requires speech services, that service must be provided. We don't care if the CBA says speech paths don't have to serve this violent kid. We don't care if the CBA says the speech paths caseload is too high. Maybe this is something for you guys to find out in the CIR or whatever the state equivalent is in California, but that does nothing to excuse the district's obligation to serve the kid.
I think Norby would say you gotta hire.
Norby would say you gotta hire or a contract with a third party.
Who's Norby?
Sorry, Scott Norby is the attorney that represents the teachers union in Nebraska in these collective bargaining cases. I think it's very possible that the CIR in Nebraska might say that this was a prohibited subject to put into the collective bargaining agreement. Don't get yourself into this position. Don't put it into the CBA. But the point is, every so often we still get a call from a superintendent who says, I can't get a pair hired. So, there's nothing we can do. I don't have any more. The school psych got pregnant and quit and moved to North Dakota with her husband. There's nothing we can do. It does not matter. Impossibility is not really a defense to not implementing the IEP. What the courts are going to say is, you wrote that in the IEP, you got to find a way to provide it, no matter what. This is a case from Nebraska. It's old, but it is a case and I give this to you if you're going to go back and train your staff. I really like talking to staff members about this case because I think it really makes the point in sort of a less negative way about how important it is to implement the IEP. So this is a student that's severely disabled. She's got cognitive disability. She's visually impaired. And the family had brought a note from the, I think it was their medical provider who also had some kind of mental health or psychologist. Anyway, a medical doctor had said to papoose the child when she got worked up. So basically wrap her up in a blanket. And the teacher did that, wrapped the student up in a blanket, and mom comes to visit the classroom. And when mom walks in, the student is laying on the floor, kind of off to the side, wrapped up in this blanket. Mom claims that she saw flies crawling over the girl's face, claims that the student had been wrapped up and just sort of discarded off to the side for more than an hour. Now, Steve Williams is making a gesture like, what? But when you start talking about the facts of this case to teachers and you say the student was wrapped up in this blanket, she was laid aside, teachers start going, oh my gosh, no. And then I say, who won this case? And the teachers universally said, oh, the parent won this case. This is outrageous. And the truth of the matter is the school won this case. Now, notice the 8th Circuit said, this is not optimal. This is not what we want teachers to be doing in the classroom, but it was professionally accepted because it was recommended by the therapist and it was written into the IEP. The 8th Circuit says because wrapping was in the IEP, the teacher was immune from individual liability. So if you have that kind of crabby teacher that doesn't want to implement the IEP with fidelity, thinks the behavior intervention plan is stupid, I like this case sort of to tweak that negative teacher's like self-defense instincts to say, look, that IEP is not your enemy. That IEP is your best friend. That is your best defense against a parent claim that you acted improperly, even in an extreme case like this where the student was wrapped in a blanket. So we're on the downhill side. This is just the case that says even if the accommodation is stupid, you have to do it. This kid had an FM transmitter and then had cochlear implants put in over Christmas break. And then when he came back, the teacher knew enough about cochlear implants to know that you shouldn't be using an FM transmitter when you have cochlear implants newly implemented. So the teacher stopped using the FM transmitter and the court said, doesn't matter. The classroom teacher is required to implement all the components of the IEP, even the ones that the teacher may not disagree with or care to implement. And I always add, even the ones that are stupid. I'm trying to hit the high spots here. This is oh gosh, this poor Oregon school really involved a student on the spectrum, tried to hire somebody to implement the IEP. They offered over and over again, people they tried to hire couldn't pass the drug test, they wouldn't show up, or they'd show up the first day and the kid would start beating the crap out of them and they'd be like, I'm out, I'm not doing this. And so the district could not find a parent to serve the kid. On the other hand, the behavior specialist, the kid never came to school. So the behavior specialist is like, you know what? I don't even care that you're paying me not to work. I'm not driving for an hour, sitting in a room with nothing to do, and then going home. So she resigned. Look at the last bullet point. The district said, we'll pay you double. You come sit in an empty room when the student's not here, we'll pay you double. The person still resigned. School reaches out to the State Department of Ed and said, can you help us find somebody? They said no. When the family filed a complaint with the Department of Education said school district was in violation. Department of Ed basically said, you wrote it into the IEP. It doesn't matter that you can't find a parent. It doesn't matter that your ABA therapist quit. You got to find a way to do it. Okay, I'm going to skip this one. Well, let me do this one real quick because I do see this a couple times. This is an IEP that says the kid gets to use his cell phone in class to take pictures on the notes, but of course he's using his cell phone to Snapchat instead, right? Teacher said that's stupid, took the phone, and then the family filed a complaint alleging that was a violation of the IEP, school lost. So don't write stupid stuff into the IEP if you're not willing to live with it. If you say we're a one-to-one school, student can have iPad, and then student watching porn on his iPad, you can't just unilaterally take that iPad, right? You're gonna have to call an IEP meeting and take the iPad out of the plan before you just unilaterally do it. Okay, it's 12 o'clock. I told you we wouldn't get to IEE. I knew we wouldn't. This is a topic we are gonna come back to because we've had a bunch of requests for publicly funded IEEs. Thank you so much for sitting in on the webinar. If you have text message questions that we haven't gotten to, we'll try to answer them in the next minute or so. We'll send out an evaluation and a link to the slides in the recording. Please give it, we crave your feedback. We want these to be good. So please let us know your honest thoughts about this format and what we should do that's good or not good.
What sped topics you want us to get.
And include, yeah, we get so many requests for special ed, continuing ed. If you would let us know what subtopics you want us to talk about, we are happy to find a way to get that done. All right, everybody, stay warm. Bye-bye.